You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se les comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre, y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
All right, Your Honor, we're ready. Thank you.
All right. No worries, Ms. Abraham. Good afternoon, everyone. My name is Keith Carson. I'm one of the circuit judges here. I'm going to be doing initial appearances today. Initial appearances is really limited to a couple of things. The first thing that I'll do is make a determination as to whether there is probable cause for the arrest that's already happened. That can be done a number of ways. If you've been arrested by warrant, a judge has already found probable cause for your arrest. If it's a new law offense, I'll take a look at the charging affidavit, and making this determination, I make an assumption that the things in the affidavit are true and correct, and whether there is probable cause. I believe many of you will probably disagree with some of the facts in your charging affidavit. I completely get that. Today's not the day for that discussion. You should save that discussion for your discussions with an attorney and your trial judge, which I am unlikely to be. Then we're going to talk about conditions of bond, if any, that will satisfy the state and get you back to your lives while these cases are pending. And then finally, I'll make sure that you have an attorney on board if you qualify for their services. We're going to start with some of the out-of-county warrants. The first is Guerrero Perez.
Your Honor, he's going to need the services of the interpreter.
Good morning. Good afternoon. This is Dalia Romero, Spanish interpreter on the line.
Good afternoon.
Already sworn in today.
Good afternoon, Ms. Romero. Ms. Romero, we have Mr. Guerrero Perez. He's at the podium at the jail facility, and you'll be doing the interpreting over the intercom system. The case number is 2021 CF 12606.
Thank you, Your Honor.
Good afternoon, Mr. Guerrero Perez.
Buenas tardes, señor Guerrero Pérez.
Buenas.
Good afternoon.
Mr. Guerrero Perez, you have been arrested on an Orange County warrant. It alleges 3 counts.
Señor Guerrero Pérez, usted ha sido detenido por una orden de arresto del condado de Orange, 3 diferentes causas.
The first count is racketeering.
La primera causa es crimen organizado.
The second count is conspiracy to commit racketeering.
La segunda causa es conspiración para cometer crimen organizado.
Third allegation is unlawful use of a two-way communication device.
Y la tercera causa de uso ilícito de un aparato de comunicación de 2 vías.
Another judge has already found probable cause for these allegations.
Ya otro juez ha hallado que hay causas que respaldan este alegato.
Your bonds are set in the following amounts.
Las fianzas en su caso van a ser las siguientes. Sorry.
$50,000 is to count 1, $50,000 is to count 2, and $5,000 is to count 3.
En la primera y segunda causa, la fianza son de $50,000 en cada una, y en la tercera causa, la fianza es de $5,000.
We'll let Orange County know that you're here with us, and they'll come get you.
Le vamos a dejar saber al condado de Orange que usted está aquí con nosotros para que ellos le vengan a recoger.
I'll appoint the Office of the Public Defender to represent your interests.
Y le designo la Oficina de Defensores Públicos para que les represente.
Thank you very much, sir.
Muchísimas gracias.
While they have the interpreter on the line, can we just verify that he doesn't have a private attorney?
Mientras tenemos la intérprete en la línea, pudiéramos verificar que él no tiene un abogado particular.
We can ask him. We don't have, our clerks don't have access to Orange County's records.
Le podemos preguntar porque la actuaria no tiene acceso al récord de Orange.
Mr. Guerrero Perez, do you anticipate hiring a private attorney?
Señor Guerrero Pérez, ¿usted piensa contratar un abogado particular?
Sí.
Yes.
You know if that's already been done?
¿Sabe usted si ya eso se ha logrado?
Sí.
Yes.
Can you share with us the attorney's name?
¿Puede compartir con nosotros el nombre de ese abogado?
Scott.
Scott.
Is that Mr. Roger Scott?
¿Ese es el señor Roger Scott?
I don't remember his first last name.
Gotcha. Right, is it a Mr. Scott or a Ms. Scott?
¿Es el señor? ¿Es un hombre o mujer?
He's a man.
Okay.
Male.
All right, I'm going to at this time withdraw the appointment of the Office of the Public Defender. It sounds like you've already got a private counsel on board. They will need to file some paperwork with the Orange County Clerk of the Courts.
Bien, voy a retirar el abogado defensor público. Parece que ya usted ha contratado un abogado y él necesita presentar documentación de la representación de él.
Thanks.
Gracias.
Ms. Ibrahim, are there any other potential clients that need the services of an interpreter?
Just one moment, Your Honor. No, Your Honor.
Mr. Romero, thank you very much for your help.
You're welcome, Your Honor. Have a good afternoon.
You as well.
Thank you.
William Jump. Good afternoon, Mr. Jump.
Hello.
Mr. Jump, you are with us based on an arrest. There was an active warrant out of Pinellas County alleging a violation of probation in 2019 CF 9235. The allegation being a grand theft violation of probation. They have issued no bond. Unfortunately, going to remain with us on no bond until we can get you over to Pinellas County, and we will let them know that you are with us. Ms. Ibrahim, is the Public Defender's Office asking for provisional appointments or not on the out-of-county stuff?
I know there was a point in time that we were, we'll just say yes for now.
Okay.
Thank you, Your Honor.
Mr. Jump, I'm going to provisionally appoint one of our assistant public defenders to be a voice for you, so you don't sit there too long. Thanks.
Okay. Thank you, Your Honor.
Yes, sir. Jaron Benson.
How you doing today, Honor?
I'm pretty good. Thanks for asking, Mr. Benson. Mr. Benson, you were arrested based on my warrant directing the clerk to issue a capias for a new law offense. That offense is an allegation of scheme to defraud, a third-degree felony allegation. You do have a bond on that case in the amount of $1,500 with the special conditions that you not return to the scene where that is alleged to have occurred. You have a second case with us. Unfortunately, that's a bench warrant. The allegation being that you failed to appear for arraignment back in 2018. Warrant went out on December 5th, 2018. Judge Tynan, my predecessor, issued no bond on that warrant. You're going to remain on no bond until you can get in front of me and we can figure out what was going on. I will appoint the Office of the Public Defender to represent your interests on both of these cases, and I've got some time this week and next, so they can get you back in front of me pretty quick.
Excuse me, Judge.
Yes, sir.
I would just like to first say I'm sorry. My parents.
Your Honor, Mr. Benson would be asking if the court would entertain a bond for him. It was from 2018, and I know he had some deaths in the family. Unclear if the mail was given to him at that time.
It was.
All right, Mr. Benson, Ms. Ibrahim is trying to have you not say something on the record that could put you in a worse situation. I'm happy to hear you out, but I think the state gets an opportunity to take a look at this allegation too. I don't know a thing about the bench warrant, so I'm unlikely to give you a bond today, but Ms. Ibrahim, if you or one of your colleagues wants to contact my judicial assistant, I can see him tomorrow or Friday.
Thank you, Your Honor.
Yep. We'll see you soon, Mr. Benson. You can explain what's going on. Jose Cruz Ortiz. Mr. Cruz Ortiz, you were arrested based on an...
I
Yeah,
apologize. Can we just waive the readings?
sure.
Thank you.
You were arrested based on three allegations in 21 CF 2963. Judge Falcone has already found probable cause for the allegations in count 1, 2, and 3, of which I am told you are aware. Your bond as to count 1 is going to be 0. Your bond as to count 2, it will be in the amount of, these are in an unusual order. Yeah, the bond as to count 2 will be set in the amount of $4,000. Your bond in count 3 is none. And I will appoint the Office of the Public Defender to represent your interests.
Your Honor, defense will be asking for a bond in this case. State hasn't proved proof evident presumption great at this time, so defense will be asking if the court would be inclined to give Mr. Cruz a bond.
Initial appearance, judges are not required to conduct an Arthur hearing. Mr. Cruz Ortiz will remain on no bond pending any written motions in front of his trial judge. I'm not sure who that's going to be. Is that going to go?
I think it's Young. Let me make sure.
We believe this is going to be assigned to Judge Young.
Thank you, Your Honor.
All right, thanks.
It is Judge Young.
Jerome Hall.
Yes. And Your Honor, we would be waiving the readings of this case as well.
Thank you, Mr. Hall. You were arrested on one count in 21 CF 2781. Another judge has already found probable cause for that allegation, which I'm being told you are aware. The original charging affidavit charged a first-degree felony. The information is charged as a second-degree felony. Does Mr. Hall have a bond? All right, looks like Judge Young indicated that the first appearance judge may consider a bond as long as that bond has no contact with the victim. And does the state wish to be heard as to consideration of bond?
Just for the record, Your Honor, this defendant has no prior history.
Thank you, Officer Young.
One moment, Your Honor.
Of course.
Your Honor, if I may, defense would just be asking for a bond as there was no pretrial detention motion given to the defense prior to this hearing. And as it is charged as an F2, he would be entitled to one.
Your Honor, state leaves it at the court discretion.
Thank you. Do we know if the victim was noticed of today's proceedings?
No, Your Honor, the victim has not been notified.
Right, there does not appear to be a pretrial detention motion before the court. Mr. Hall is charged with a second-degree felony allegation, which indicates that he is entitled to bond. The court is going to set a bond in this case in the amount of $15,000, the special condition that he have no contact whatsoever with the alleged victim as alleged on the information. There's also a standard condition and will be imposed that he not possess any weapons or firearms.
I don't own any weapons, sir.
All right, thank you, sir. And
Could I say one?
Pursuant to statute, the victim will need to be notified as to Mr. Hall's granting of bond.
I apologize, Your Honor.
Thank you. I'll appoint the Office of the Public Defender if they weren't previously appointed.
Thank you.
Thank you, sir.
Desmond James. Good afternoon, Mr. James.
Good afternoon, Your Honor.
Mr. James, you were arrested based on a warrant from Judge Epperson. Judge Epperson indicated that you may have failed to appear for a county diversion rejection hearing. He did set a bond on that case in the amount of $2,999. The case number is 2019 MM 2930. I'll appoint the Office of the Public Defender to represent your interests. Thank you, sir.
Thank you.
James Mitchell.
Good afternoon.
Good afternoon, Mr. Mitchell. Mr. Mitchell, you were arrested pursuant to an arrest warrant. Judge Sanders Morency found probable cause for the following counts: possession of counterfeit driver's license, fraudulent use of personal identification information, and scheme to defraud, and has assigned bonds in the following amounts. Count 1 is bond is set in the amount of $1,000. Bond in count 2 is set in the amount of $5,000. Bond in count 3 is set in the amount of $1,000. And I will appoint the Office of the Public Defender to represent your interests. Thanks.
Thank you.
Alberto Rivera. Good afternoon, Mr. Rivera.
Good afternoon.
You got a variety of stuff with us, the first being a bench warrant in 2020 CF 2847. The allegation being that you failed to appear for pretrial in that case. Those allegations are possession of methamphetamine, possession of drug paraphernalia. Judge Nix Walker did grant bond on that failure to appear warrant. Bond in count 1 is set in the amount of $2,000, and bond in count 2 is set in the amount of $2,000. There's also a bench warrant in this case. That is from Judge Jansevich. The allegations being that you failed to appear for a plea date certain back on December 15th, 2020. She issued a warrant for you with no bond. You'll remain on no bond until you can get in front of her and let her know what's going on. You also have another warrant. That was a warrant for failing to appear for a plea in 20 CT 97, that allegation being driving while license suspended, also in front of Judge, I think that was also in front of Judge Jansevich. Again, on that case, she issued no bond. You'll remain on no bond. The final issue is that you are here based on an allegation of violation of probation in 2020 CF 1488. The original affidavit, or the original warrant, contemplated a bond of $1,000. However, based on the court having probable cause to believe that new law offenses have been committed while you're on probation, the court's going to find an on-view violation of your probation, and your bond in the violation of probation case will be none. So you got a bond on the new case and no bond on the 2 failures to appear and the violation of probation. I'll appoint the Office of the Public Defender on all 4 of your cases. Thanks. Hans Thomas Tileston. Good afternoon, sir.
Good afternoon.
Sir, you were arrested based on a warrant. That warrant was signed by Judge Strobridge. He found probable cause for 2 counts. Count 1 is possession of a controlled substance without a prescription, and count 2 is possession of drug paraphernalia. She has assigned bonds on count 1 in the amount of $1,000 and count 2 in the amount of $500. I can't tell how long ago this warrant was.
I have that information, Your Honor.
Officer Hill?
One moment, please.
I see that Mr. Towson is out.
His,
on another
the
case.
date of offense on this warrant is April 5th, 2021. He posted bond on the 20 CF 2508 on August 31st, 2020. So this offense would indeed violate the bond conditions of that 20 CF 2508.
Thank you. Mr. Toston, you've got a bond on the new case. The bad news is that the court has probable cause to believe you committed a felony offense while you're out on bond on another felony in 2020 CF 2508. That's in front of Judge Nix Walker. Your bond is going to be revoked on that case, and you're going to remain at no bond until you can get in front of Judge Walker for consideration.
I was in front of Miss Walker on Monday, and nothing was ever said about this.
Okay, I don't think she may have known about the new law offense and your arrest. Did your attorney advise Judge Nix Walker about your new arrest?
I don't know. I didn't know I had a warrant. Kristen Kronk is my public defender.
Okay,
They showed up at the house last night and just said you had a warrant. I didn't even know I had one.
I got you. Well, the warrant, just so have you had a chance to read through the affidavit?
No, I haven't.
It alleges that on April 5th, 2021, there was a search by law enforcement that some brown powdery substance was found, and it took that long, I guess, to test what that was. I don't want you to talk about the facts of the case. I'll appoint the Office of the Public Defender to represent your interests. Your PD will know how to get you in front of Judge Nix Walker for consideration of a bond on the old case. Thanks.
Your Honor, would the court consider staying the bond in his old case, since it's been since April till October before he even was picked up on this and doesn't have knowledge of it?
No, there's probable cause at this point to believe a felony was committed while he was out on bond. So till he can explain that and talk it through with Judge Nix Walker's bond's going to be none on the old case.
Thank you, Your Honor.
Thanks.
And Your Honor, just for the record, he is out on bond on another case as well. However, the other case, the dates would not violate.
I understand, thanks. So I won't take any action on the third case, which is currently pending. John Fitzgerald Davis. Mr. Davis, good afternoon.
I apologize. This client asked to have his readings waived.
Okay, I was just going to inform him that he's here on a bench warrant for an allegation of failing to appear for jury trial in 2021 CF 1931. Judge Nix Walker issued a arrest warrant with no bond. He's going to remain on no bond until he can get in front of her.
Do I have a court date reset because I got arrested?
Let me see if you got any court dates, Mr. Davis.
Because it was supposed to be in trial, the case supposed to have been dismissed.
I have November 3rd at 9:30 a.m.
We've got you currently down in front of Judge Nix Walker on November 3rd,
Okay,
so.
can you tell me the court date on my
No.
November 3rd?
Yes, sir, Mr. Davis.
Thank you, sir.
Yes, sir. Eric Yurney? Good afternoon, sir.
Good afternoon.
Would you pronounce your name for me?
Your
Urani. Sir Urani, you are here with us based on a warrant. Judge Falcone found probable cause for burglary of an unoccupied structure, and grand theft. Did assign bonds on that case. Bond in count 1 set in the amount of $2,500, and bond in count 2 is set in the amount of $1,000, with the special conditions that you not have any contact with any alleged victim and you not return to the scene of the offense. I will appoint the Office of the Public Defender to represent your interests.
Thank you, Your Honor.
Yes, sir. Jennifer Avery.
One moment, Your Honor.
No problem. Good afternoon, Ms. Avery.
Good morning.
Feels like morning, it's actually afternoon by now.
Oh, morning.
Ms. Avery, you were arrested based on allegations of fleeing or attempting to elude a law enforcement officer and driving while license revoked as a habitual traffic offender. I have found probable cause for your arrests in count 1 and count 2. Bond in count 1 is set in the amount of $2,500. Bond in count 2 is set in the amount of $500. Unfortunately, you are also out on bail on an Orange County case in 2021 CT 6651. That's an allegation of DUI. Your bond is going to be revoked in that case until we can get you over to Orange County and explain to that judge what's going on with these new allegations. And we will let them know that you are here with us. Your bond on that case will be none for the time being. I'll appoint the Office of the Public Defender to represent your interests. Thank you.
Your Honor, she has a second case.
Is it 2 counts of driving while licensed?
I saw it.
Yes.
This one occurred before.
Avery, that's not very nice. Okay, there was a second allegation of driving while license suspended as well. I do find probable cause for that allegation. Bond in that case be set in the amount of $500.
Your Honor, I would just like to clarify on that second driving on suspended license ticket, because it appears that it stemmed from the same incident.
I thought the same thing.
I looked it up.
So the defense would argue the probable cause on that second ticket.
Hold on, let me get,
10/6/21, and this occurred.
So Bell's 5.
10/12. One was 10/12 and the other one was 10/6.
It appears that, no, on October 6th. The uniform charging affidavit has the date as 10/6. Okay, hold on. The date of arrest was 10/12. This is the same offense. It's the same.
Well, on the, on case 21 CF 2968, the violation date was 10/12 and the arrest date was 10/12. On the 21 CT 2804, the violation date was, give me a second, 10/6, so that was before. And then she got arrested on 10/12.
There's no probable cause to believe that she was driving on October 12th pursuant to the charging affidavit. There is probable cause to believe that she was driving on October 6th. Hold on a sec. Last sentence indicates, based on the information when I made contact with her on October 6th, have probable cause to charge her with driving a motor vehicle with a suspended driver's license. So as to it also references the traffic citation. So it seems like the second case is a duplicative case. So in 21 CF 2964, I've set bonds for the fleeing or attempting to elude and the driving while license suspended or revoked. 21 CT 2804, I'm going to ROR. Not sure whether there's probable cause for that case. And Orange County case 21 CT 6651, bond is revoked. All right, thank you. Matthew Brown.
One moment, Your Honor.
No problem. Where's the VOP assigned?
It's on the view.
I know, but is it mine or is it Judge Young? Good afternoon, Mr. Brown.
Good afternoon.
Mr. Brown, you have a new law offense with us. That's an allegation of resisting an officer without violence. I have read the charging affidavit, and you find probable cause for your initial arrest. Court's going to set bond in that case in the amount of $250. Fortunately, you are also on probation in felony case number 2020 CF 2319. The court finds there's probable cause to believe you committed a new law offense as well as violated your probation. In that case, bond is going to be set at none until you can get in front of Judge Young, let him know what's going on, and I will appoint the Office of the Public Defender to represent your interest.
Your Honor, do we know if a private attorney has been issued at this point?
We'll check for you. Hold on a sec.
Let me check again, but.
We checked before court started. We didn't see a notice of appearance. Which attorney do you anticipate will be?
It should be Sean Landers, the same one who represented me the first time around.
Got it.
Nope, no notice hasn't.
So in order to have you not be in there without any voice, I'm going to provisionally appoint the Office of the Public Defender. Mr. Landers can substitute in for the Public Defender's office anytime they're retained.
Okay.
All right, thanks. Ivan Cuesta. Is it pronounced Cuesta, sir?
Yes, sir.
Good afternoon, sir.
Good afternoon, Your Honor.
Sir, you were arrested for 4 counts. First is domestic battery by strangulation, the second being battery domestic violence related, the third being tampering or denying someone of a communication device in a third-degree felony proceeding, and the fourth allegation is criminal mischief of $1,000 or more. As to counts 1, 2, and 3, the court does find probable cause. As to count 4, the court finds that the affidavit is insufficient to establish probable cause. As to count 4 only, you'll be released on your own recognizance. As to counts 1, 2, and 3, you'll receive a bond. Bond in count 1 is set in the amount of $3,500. Count 2 in the amount of $500. As to count 3 in the amount of $500, with the special conditions that you are to have no contact whatsoever with Denise Gonzalez Santana. And I will appoint the Office of the Public Defender to represent your interests. Ms. Ibrahim, do you wish to ask whether they cohabitate?
Yes, Your Honor.
Thanks.
Your Honor, has PTR had an opportunity to reach out to this alleged victim?
We did make attempts, but there was no answer. We left a message and we did not hear back.
It's my understanding that he doesn't qualify for some kind of out-of-state warrant.
Meaning?
And they do reside together, Your Honor.
Okay. Mr. Cuesta, you're not going to be able to go back to the property where this is alleged to have occurred. I'll allow you to return one time with law enforcement to get your personal belongings to tide you over until this gets sorted out. Thanks. William Hensley.
Your Honor, I apologize. In the last case with Mr. Katusta, was there a private attorney that put a notice of appearance in?
Private attorney for Mr. Cuesta.
Oh, no.
Yeah, we're not showing a notice of appearance, so the attorney of his choosing can substitute in for the public defender's office.
Thank you, Your Honor.
Thank you. William Hensley, thanks for your patience. Mr. Hensley, you were arrested based on new allegations of possessing a controlled substance and possession of drug paraphernalia. I do find probable cause. I'm going to reduce your bond in count 1 to the amount of $1,000 and your bond in count 2 in the amount of $500. Unfortunately, you're out on bond on 2 other felony cases. One is 2021 CF 2743 and the other is 2021 CF 1185, both here in Osceola County. I have probable cause to believe you committed a new law offense while you're out on bond on those cases. I'm going to revoke your bond on those cases. I don't know where you're headed. Do we know where Mr. Hensley's cases are assigned?
Your Honor, they're assigned in front of Your Honor. I do represent Mr. Henley on his cases. I do know that one of the cases was set off for PTD.
Okay.
And so I would just ask that we stay the bonds in his cases and that I work with Mr. Hensley upon his release.
Okay. Yeah, I'm going to revoke his bonds, but you can get in front of me. Contact Ms. Hafner. I probably have some time tomorrow or Friday, and we can see whether we can have a more detailed conversation about what's going on.
Thank you, Your Honor.
Thanks. Valicia Ayanaya? Ania? Good afternoon, ma'am.
Good afternoon.
Pronounce your last name for me.
Ayana.
Ayana. Miss Ayana, you were arrested based on a second-degree misdemeanor of petty theft. The court's going to reduce your bond to $250. I don't believe that she qualifies based on some kind of out-of-county issue for PTR, but I'll reduce your bond down to $250 with the special condition that you not return to the location where this is alleged to have occurred, which is the Walmart. I'll appoint the Office of the Public Defender to represent you.
Okay.
Thanks. Christopher Johnson. Okay.
What's it say? Go for it first.
I'll give you a chance to talk to her if you have questions. Mr. Johnson, you were arrested based on an allegation of battery domestic violence. Reading the charging affidavit, I do find probable cause for the allegation. Court is going to consider a bond plus pretrial release conditions. Bond will be set in the amount of $500 with pretrial release. The conditions of your pretrial release are that you are to have no contact with Lisa Bianchi, and you are to maintain separate residences from Lisa Bianchi. Do you need to talk to?
Your Honor, has pretrial release reached out to this alleged victim?
They indicated they had, and they were there was no answer. So I've got no additional information.
That's correct. We weren't able to leave a message. The mailbox was not set up.
Okay, apparently they tried to reach out to the alleged victim, so at this point, it's no contact. If the victim requests contact, the trial judge can consider that.
And Your Honor, pretrial release here at the jail informed this client that he would have a $100 bond.
I don't know why they would do that. That's within the judge's discretion. There's nothing in the paperwork that indicates a $100 bond.
We don't recommend bonds.
And Your Honor, my client has identified that the home that this alleged incident occurred at is his home, which is registered to him, and that this alleged victim resides with her mother in a different home.
I didn't bar him from going back home. I just said they need to maintain separate residences.
Okay, thank you.
Yep, see ya. Teodros Kabidi? Good afternoon, sir.
Yes, sir.
Is your last name pronounced Kabidi?
Yes, sir.
Mr. Kabidi, you were arrested based on an allegation of trespass after warning. The court does find probable cause for that allegation. I'm going to reduce your bond to $150, and I am also going to order that you should be considered for pretrial release if you qualify. Apparently, there may be a possibility of an open case at a county. Is that correct, Mr.?
That's correct.
Okay. PTR may take a closer look at that. You may qualify for PTR, otherwise a $150 bond, and I'll appoint the Office of the Public Defender.
What is PTR, Your Honor?
PTR is pretrial release. You give them some information about where you will be, and you keep in contact with them, and it's a non-monetary bond consideration. They're indicating that at this point there may be some open case out of county that they need a chance to take a look at.
Everything's resolved. Orange County, everything's resolved. I'll take PTR, sir. Everything Orange County resolved. There was another trespass. I got time served for it.
Okay.
I will take the PTR.
Your Honor, would the court entertain an ROR as it is a simple trespass case, simple misdemeanor?
No, it sounds like he came into contact with law enforcement and then went back.
That's all.
Okay. Okay. Capiti, I understand that you disagree with the allegations in the charging instrument. Like I said, that's going to be a discussion for your trial judge, which is not going to be me, and your attorney. If there's some defense to this, certainly share that with them. Also, let PTR know about whatever issues you have in Orange County. If you believe that those are closed, they'll look into that, and you may qualify for PTR. I do not have a preference as whether you're on PTR or have a $150 bond.
The one that we are looking into, that we need more information on, is out of Miami-Dade.
Okay. They're looking at something out of Miami-Dade, Mr. Kabidi, so I don't know what's going on down there. So if you want to share some information with them, that may alleviate their concerns, and I have no objection to you participating in PTR if you qualify. Thanks. Johnny Neal. Good afternoon, Mr. Neal.
Good afternoon.
Mr. Neal, you were arrested based on allegations of sending a written threat and stalking. Count 1 is a second-degree felony allegation. Count 2 is a first-degree misdemeanor allegation. I have read the charging affidavit and do find probable cause for your initial arrest. You do have bonds on both of your counts. Bond in count 1 is set in the amount of $5,000. Bond in count 2 is set in the amount of $1,000. Court's going to add the special conditions that you not have any contact whatsoever with Mr. or Mrs. Lurs, that you not return to the Miracle Springs Church or the 1531 Tallahassee address as a condition of your bond, and I will appoint the Office of the Public Defender to represent your interests.
Oh, yeah.
Thank you. Angel Nickerson. Good afternoon, Ms. Nickerson.
Good afternoon.
Ms. Nickerson, you were arrested based on an allegation of petty theft. Do you find probable cause for that allegation? I'm going to reduce your bond down to $250 and have the special condition that you not return to the Walmart. Ms. Ibrahim, it doesn't look like she qualifies for PTR. Ms. Officer Hill, can you tell me?
Yes, she has an active warrant out of Gilchrist County. There is a hold-in-place juvenile pickup order for a VOP.
Okay. Just so you know, there's a active warrant and a requested hold, so you may want to talk to Ms. Ibrahim or your attorney about whether you should post the bond at this point. I'll appoint the Office of the Public Defender to represent you. Thanks. Roy Ortega.
Do you know if there was bond on that warrant or that VOP?
I didn't see a bond, but I'm not sure at this time.
Thank you.
Good afternoon, Mr. Ortega.
Good afternoon.
Mr. Ortega, you were arrested based on resisting an officer without violence and criminal mischief of $200 or less, both misdemeanors. Court finds probable cause for those allegations. Bond in count 1 is set in the amount of $500. Bond in count 2, bond in count 2 is set in the amount of $250, and I'll appoint the Office of the Public Defender to represent your interest. Thanks. Gregory Smith.
And, Your Honor, we'd be waiving the readings in this case as well.
Thank you.
Hello, Your Honor.
Good afternoon, Mr. Smith. Mr. Smith, you were arrested for 3 counts of which I am told you are aware. You do qualify for consideration of bond on each of these allegations. I have read the charging affidavit and I do find probable cause. Your bond in count 1 is going to be set in the amount of $1,000. Your bond in count 2 is set in the amount of $1,500. Your bond in count 3 is set in the amount of $5,000. You're to have no contact whatsoever with the named victim in the charging affidavit, and you are not to return to the Sawyer Circle address. I will appoint the Office of the Public Defender to represent you. Ms. Ibrahim, do you wish to ask whether he has some personal belongings at that property?
Yes, Your Honor, if I can have a moment. Yes, Your Honor, he does have belongings at the residence.
Court will allow him to return to that property one time with law enforcement to collect some personal effects so he can have his things while this case is pending. And that will conclude our hearing. Thanks. Crystal San Pedro Thayer. Good afternoon, Ms. San Pedro Thayer.
Good afternoon, sir.
Ma'am, you were arrested based on allegations of petty theft and possession of a controlled substance. I find probable cause for your arrest. I'll set bond in count 1 in the amount of $500, and count 2, I'm going to reduce your bond to the amount of $1,000. Fortunately, you're out on bond on another petty theft in 2021, MM2317. I believe you're out on ROR on that case. No, you're out on bond on that case, and you're out on ROR in front of Judge Young in 2021, CF2310. In the felony case, the court has probable cause to believe you committed a new law offense while you're out on ROR. I'm going to revoke your ROR and set bond in the amount of none. As to 2021, MM2317, the court has probable cause to believe you committed another petty theft while you're out on petty theft, so the court's going to revoke your bond on that case. Your attorneys can get you in front of Judge Yansevich and Judge Young and explain the situation to them for consideration of bonds on those cases, and I'll appoint the Office of the Public Defender on all 3. Thanks. Cecilia Center.
Your Honor, she's in detox at this time.
All right.
Just want to verify that this was a reset from yesterday.
And the day before, is she medically unable to attend court?
Yes, Your Honor, I did speak with them this morning, and she is still sick.
All right, thanks. We're going to reset in the center for tomorrow. We'll try again.
Thank you.
That was the last of cases that I had on my list. Ms. Ibrahim, do you have any additional?
I have a Paul Koval.
He bonded.
He bonded?
He bonded prior.
Present, okay.
He's present?
He's present.
Okay. You can let him know that someone posted bond for him and he's being processed out.
Thank you. I don't believe we have anybody else. Thank you, Your Honor.
All right. Thank you for your help, Ms. Ibrahim.
Have a good afternoon.
You as well.
Thank you.
Okay, I just made this go live. We have a large calendar for today. So I'm going to start. Looks like we have both sides available. And when the interpreter comes on, we'll deal with Miss Katiana?
Your Honor, we'll also need the interpreter for, I believe, Mr. Wilmer.
Okay. Mr. Wilmer has a lot of charges. Took up almost 100 pages. Okay, I'm ready to begin. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by a jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Whether bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear affirm that any statements or testimony you make during this proceeding will be the truth, the whole truth, so help you God? I also want to make another statement. We have approximately 44 people on the calendar. And as the judge, I'm the person that prepares the paperwork that gets sent over to the jail. I'm trying to move this along as quickly as possible. All but one of you have bonds that are set. And so the longer this proceeding goes on, the longer you're going to sit in jail. So if you have a question, I'm here to answer any question that you may have. But keep in mind that the longer this proceeding goes on, the longer you're going to be in jail before these bond orders get entered. And I just want to put that out there just as a sort of, I guess, truth in advertising. Attorney Brown, let's bring up Miss Jones. Ms. Jones, I would normally speak to you directly, but you've taken advantage of the opportunity to hire an attorney. So I'm going to speak to your attorney about your case. I need you to understand that anything that you say during this proceeding is not privileged nor private. So don't say anything that you would not want the whole world to know. Do you understand that, ma'am?
Yes.
Okay. Attorney Brown, your client has been charged with simple assault, criminal trespass, and impersonating an officer. And I gave you the bond amounts earlier, $4,000 for the simple assault, $1,500 for the criminal trespass, and $500 for the impersonating officer. But I'll listen to you, ma'am, about anything you want to tell me about this case or your client.
Yes, Judge. On behalf of Ms. Jones, her husband is here, Detective Jones. She's a life resident of Clayton County. She resides at her home. She has two children, ages 15 and 22. She doesn't have any prior criminal history. This is a situation where she had a day laborer working for her that didn't have a license. She would transport him to and from her home. She went out to his home to meet with him. He wasn't there, and the person there didn't speak English. And so in an effort to try to understand what was going on, I think she called another person and there was a misunderstanding, and she thought that Ms. Jones was perhaps from the police or immigration. And that is how, this situation arose. I don't think at the time that Ms. Jones was out there, the police were called. I think they were called after she had left the premises. And then she was informed that there was a warrant. So, Judge, I think the evidence is just going to show that this was a misunderstanding. Ms. Jones doesn't have any criminal history. I know that Your Honor has set a bond. It looks like $6,000 total. I would just ask the court if you would consider reducing that by half. We are in a pandemic given COVID. She doesn't have any criminal history, and she has two children that she cares for. Well, one is an adult, but in these days and age, they're always in your pockets. So I would ask the courts if you would consider reducing the bond by half, Judge.
What would be the basis?
Judge, just in terms of her financial situation, I've spoken with the husband and in trying to, I know $6,000 is not a lot. I mean, it's a relatively low bond as is, but just given their family situation and their finances, they've asked that I ask the court to reduce.
I'm really not inclined to do that, Attorney Brown, because I try to set similar bonds for everyone. So everyone charged with simple assault has a $4,000 bond. Actually, let me rephrase that. It has a $3,000 bond. So I'll reduce the simple assault from 4,000 to 3,000. But I have also placed a stay away provision on the bond to stay away from a Rosa Munoz. And I'll tell you the basis of trying to set uniform bonds so that no one feels that they're getting special treatment or they're being treated any differently than anybody else based upon the allegations. I understand your presentation as it relates to the events, but it's just something that I feel very strongly about, that people bring trouble into their lives by their actions. And I try to set bonds, even though they're not high, I try to set bonds so that people will think before they act. So I'm going to leave it. There's going to be $3,000 for simple assault, $1,500 for the criminal trespass, and $500 for impersonating an officer. She's going to have a preliminary hearing date set for November 30th at 8:30 in the morning. That date will get waived upon her bonding out, and she'll get a new court date in the mail. So is there anything else?
No, Judge.
Okay. Well, I appreciate your advocating on behalf of your client. And I hope that I was at least clear so that people understand why I do what I do or did what I did. Is that, I guess, I mean, if is that clear, or is there anything else?
No, Judge, that's perfectly clear.
Okay. So, Ms. Attorney Brown, you are free to leave, and Ms. Jones, you are free to go back. I see there's, thank you. I see there's a attorney Roland Cox.
Yes, Your Honor. Good morning. May I please the court?
Yes, sir. Who are you representing?
I represent Sunny Sunday.
Okay.
And go ahead.
Well, I was going to say, I'll get to you in a second. We have two people that I need the services of the interpreter. So I'm going to deal with those two individuals. And what I will ask is that we deal with Mr. Wilmer. Well, we'll deal with Miss, let's see, what's her name? Miss Cayetano.
Ms. Cayetano, Your Honor,
How are
yes.
you doing, Ms. Tolles?
I'm well, Your Honor. How are you? You mentioned the name of the other person I'm going to help. What was the last name? I didn't see him in my list.
So there's the name on the list is Jorge Alberto Aguilar Moran.
Yes, sir. I do have that name. I see. Okay.
But it seems like his name may be Wilmer Machado.
Okay.
And
all right.
That's going to be something we're going to have to figure out.
Okay.
So, Miss Adamson, if you can hear me, I still have not received. Nope, I do have them. The CAA forms. Okay, so I'm gonna keep those over here. And I'll just deal with those on the fly. I'm on third shift warrants this week, so I've been up since very early this morning. So you gotta excuse my lagging a little bit. I think she may have made bun. How to pronounce her name, Miss Tolles?
Miss Cayetano.
Cayetano. Miss Cayetano, can you hear and understand the interpreter?
Señora Cayetano, ¿puede usted oír y entender al intérprete? Yes.
Speak up too.
Me está diciendo que hable más fuerte. Gracias, señorita.
Do you know if your bond has been set? I'm sorry. Do you know if your bond has been paid?
Señora, ¿sabe si ya se pagó su fianza?
Creo que sí, ya me habló mi esposo y dijo que ya la habían pagado.
I think so. My husband called and said that they've already paid it.
Okay, because and the reason I asked is because I didn't get the warrant paperwork in it normally, and she's charged with an offense.
Le pregunto porque no recibí los documentos sobre la orden de arresto y usted tiene una infracción.
That the bond is automatically set?
Donde se determina, se impone la fianza automáticamente.
And generally, when I don't receive the warrant, it means that the bond has been paid and her file is in bonding.
Generalmente, cuando no recibo los documentos de la orden judicial de arresto, eso significa que los documentos ya están en el departamento de fianzas. Se está tramitando.
So, ma'am, I will let you go back and you will probably receive a knock on the door soon that you're pack your stuff so you can go home.
Entonces voy a dejar que usted se retire, señora. Lo más probable es dentro de poco le van a avisar que ya puede alistar sus cosas para irse.
Sí, gracias.
Yes, thank you.
Okay, ma'am, you're free to go back.
Okay, ya se puede retirar. Gracias, señora.
Gracias.
Thank you.
Mr. Machado.
Good morning.
Sir, can you hear and understand the interpreter?
Señor, ¿usted puede oír y entender al intérprete?
Sí.
Yes.
What is your true and correct legal name?
¿Cuál es su nombre completo, verdadero, correcto y legal?
Jorge Alberto Aguilar Morán.
Jorge Alberto Aguilar Morán.
Okay. Sir, you've been charged with offenses that bond is not going to be set for you today.
Bueno, señor, las acusaciones de su contra, por el momento no se le va a imponer fianza por esas acusaciones hoy.
You're going to have bond set on the 2 family violence battery charges.
Sí, se le va a poner la fianza por las 2 acusaciones de violencia intrafamiliar.
And they're going to be set at $5,000 each.
Y la fianza será $5,000 para cada una.
You're going to have
Perdón, señor, para cada uno,
¿Cómo dice?
para cada cargo,
For each charge.
for each of the family violence battery charges. Yes.
Para cada uno de los cargos de violencia intrafamiliar, sí.
pero deben de existir pruebas para eso, señor juez.
But there should be proof for that, correct, sir?
These are allegations.
Estas son alegaciones, señor.
And my job at this stage is to determine whether bond should be issued.
Entonces, mi trabajo en esta etapa es determinar si a usted se le debería conceder fianza.
And because you've been charged with aggravated assault by strangulation,
Y como usted tiene acusaciones de agresión con agravantes por medio de estrangulación,
sexual battery,
agresión sexual,
kidnapping,
secuestro,
2 counts of false imprisonment,
2 acusaciones de privación ilícita de la libertad.
and that's the basis of me denying your bond at this point.
En eso me baso para negarle la fianza en este momento.
I have to weigh your right to be released on bond versus public safety.
Tengo que sopesar su derecho de salir en libertad bajo fianza con la seguridad pública.
And based upon these allegations, I'm not prepared to set a bond today.
Y considerando estas alegaciones, no estoy dispuesta a imponerle una fianza hoy.
I'm going to set a preliminary hearing for November 29th at 8:30 in the morning.
Pero sí le voy a señalar su audiencia preliminar para el día 29 de noviembre a las 8:30 de la mañana.
In courtroom 201.
En la sala 201.
I'm going to also set a bond hearing date for December 3rd at 8:30 in the morning, courtroom 201.
También voy a señalar la fecha de la audiencia para determinar su fianza para el día 13 de diciembre a las 8:30 de la mañana en la sala 201.
Do you want me to see if you qualify for the appointment of a lawyer?
¿Quiere que yo determine si usted reúne requisitos para un abogado de oficio, señor?
La verdad que sí van a necesitar un abogado, pero imagino, la persona que me está acusando de esto es mi expareja, la mamá de mi hija.
I need to talk to an attorney about these things. The person that's accusing me is my ex-partner, the mother of my child.
Okay. So you're going to hire your own lawyer?
Entonces, ¿usted piensa contratar a su propio abogado?
Pues no tengo el dinero, la verdad, yo no tengo dinero.
Honestly, I don't have the money to do that.
So do you want me to appoint a lawyer to represent you?
Entonces, quisiera que yo le nombre un abogado para representarle.
Sí, por favor.
Yes, please.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you.
Está bien. Yo determino que usted sí cumple los requisitos y voy a nombrar un abogado para representarlo.
Una pregunta más.
I have one more question.
Yes, sir.
Sí, señor.
Y por ese montón de cargos que tengo en mi contra, no hay prueba. ¿Qué posibilidades tengo yo?
Due to all of these charges against me and there's no proof, what are my chances?
I don't know, sir. That is the job of the lawyer to
No lo sé,
investigate
señor.
your case.
No lo sé, señor. Ese es el trabajo de su abogado para investigar el caso.
Sí, porque la verdad que yo de esto me siento muy afectado porque es algo que no he hecho, ¿verdad?
Yes, because I'm very affected by this. This is something that isn't true.
I understand that. These are mere allegations. The state has to prove their case beyond a reasonable doubt.
Yo lo entiendo, señor. Pero por el momento, esos son solamente alegaciones. El Estado después tendrá que probar el caso fuera de una duda razonable.
Si en ese tiempo que tengo la otra audiencia no investigan nada, yo que toca libertad o pago una fianza.
May the interpreter ask him to repeat, Your Honor? I'm sorry, there was background noise.
Yes, yes.
Disculpe, señor, por el ruido de fondo no lo oí bien. ¿Puede repetir lo que dijo?
Si en este tiempo que que está en proceso, a la otra audiencia que tenga, no tienen pruebas para esto para estas acusaciones fuertes, yo pueden ponerme una fianza.
In the meantime, while this case is being processed to my next court date, even though there's no proof about these charges against me, could you give me a bond?
So a bond is possible.
Es posible que tenga fianza.
These events allegedly occurred on January 8th of this year.
Una fianza sí es posible para usted, señor. Supuestamente lo sucedido ocurrió el 8 de enero de este año.
And
Yes.
the warrants were obtained on March 5th of this year.
Y luego las órdenes de arresto se obtuvieron el 5 de marzo de este año.
And it appears that it was after an investigation by the police department.
Parece que eso fue posterior a una investigación llevada a cabo por el cuartel de policía.
So whether there's proof or not, that may factor into your case being diverted in a different direction.
Entonces, si existen pruebas o no, tal vez eso afecta si el caso sea desviado de otra manera.
Okay.
¿Está bien?
Sí, señora, está bien.
Yes, ma'am. That's fine.
Okay. You're free to go back, sir.
Está bien, señor. Ya se puede retirar.
Let's see, Mr. Cox. Who are you representing again?
Mr. Sunday, Sunny Sunday.
Okay. On the male side, can we bring up Mr. Sunday? And Ms. Tolles, before I let Ms. Tolles go.
Yes, Your Honor.
On both the male and female side, can you let me know if there is anybody else that needs the services of the interpreter?
You interpret.
Not on the female side, Your Honor.
Okay.
Not on the male side, Your Honor.
Okay. Thank you, Ms. Tolles. You have a good day.
Thank you. Have a great day.
All right. So, Mr. Is it Boyejo?
Boyejo.
Okay. Sir, I would normally speak to you directly, but you've taken advantage of the opportunity to hire an attorney So I'm going to speak to your attorney directly about your charge and the bonds that I've set. But I need you to know that there's nothing here that is privileged or confidential. So if you say anything, don't say anything that you would not want the whole world to know. Mr. Cox, can you come on the camera, please?
Morning, Your Honor. May it please the court. Roland Cox on behalf of Sunny Sunday.
Good morning. So Mr. Sunday has been charged with 3 felony counts of criminal damage to property in the second degree. I've set bond at $5,000 on each of those offenses. He's also been charged with the false report of a crime. I've set the bond at $3,000. And criminal trespass, I've set the bond at $3,000. But I will hear from you, sir, as to anything you want to tell me about bond for your client and the case.
Yes, Your Honor. May it please the court. My idea is to basically reduce his bond to its own recognizance. My client is innocent until proven guilty. He voluntarily surrendered. He will appear. This shows the court that he respects the court and he respects his and understands his responsibility and his duty to appear, and that basically the amount of bond will not be linked to his duty to appear. He has no criminal history. He's a long-term resident of the county of Clayton. He needs to be able to aid his attorney in his defense. And one of the elements of being able to do that is to pay said counsel. Mr. Sunday has child support, which is where his first money goes to. The second would be living and then the cost of this. He understands that basically responsibility, like I said, he voluntarily surrendered, spent the night in jail, and anything that the court can do to relieve or ease the burden, especially where we got the 3 charges, 555, or we could just make 1 5 on that. But once again, Your Honor, I ask for own recognizance bond. Thank you.
Okay. What I'm seeing here, counsel, is a basic allegation that he was evicted from the property. He went back to the property and turned water on to damage the property.
Your Honor, my client pleads not guilty, and I'm not involved in the facts of this case yet, but I will become involved in that as we move forward through the proceedings. Like I say, he is a long-term resident. He's not going to, he's not a non-offender, so he's not going to repeat or cause any trouble while he's out. And basically, part of the bond will that he has no contact with these people. I think there's been an ongoing dispute here, and I've just now become involved as far as having him turned in, surrendered, and setting up the bail bondsman. And my primary goal here today is to basically relieve any financial that I can, or the court can help with that, especially when we got these charges stacked so deep. I mean, one bond hold all charge. I understand that it doesn't work that way, but if anything that the court can do to I understand the schedule that basically you like to keep level and things like that. To the extent though here we have 3 charges stacked, we could keep it level by just, applying it to one. Like again, Your Honor, it's the money and lack thereof. However, wherever the court shall rule, Your Honor, we respect the court's decision and wisdom.
There is, and I'm trying to look, because I go through this stuff. Well, I've been going through this since 7 o'clock this morning because we have so many people on the calendar, and I believe that I read something about his making a statement, but I'm looking for that as we're speaking now. So I think what I was looking at this morning, was that according to the officer who sought the warrant, that he made contact with your client and that your client stated that there were 3 black subjects invading the home and made threats to kill him. And the officer made contact with your client that he would come over and then never showed. And that's the false report of a crime issue.
Your Honor, my client, English, I think, is his second language, and he also has a stutter. And so I already have a problem communicating with him. Sometimes I communicate with him through a third party. It's not to say that he doesn't understand, and I'm not making any excuses. I'm not admitting or denying any of the allegations in the warrant. I haven't seen the warrant yet. I'm just trying to help him reduce his bond. At least the 3 criminal damage charges, we could put one $5,000 on that, and then make it.
There is. So I think this is what I saw. It says the offender was evicted from the incident location on September 21st, 2021, and they referenced the case number as to the eviction, and it says on September 22nd, 2021, I heard the 911 recordings of the alleged offender stating he went inside of the incident location and turned on the lights. So I hear what you're saying, counsel, but it looks like your client may have kind of, that's where I've gotten the bond issue set, where it doesn't appear that this was like based upon at least the warrants, and apparently 911 recordings and conversations with the police. It doesn't appear as though this was like something that was accidental. So I'm going to leave the bond the way that it's set. So that's going to be a total bond of, let's see, 10, 15, 18, $21,000. There's going to be a stay away provision on the bond to stay away from a Janiah Odom. Because these are felony offenses, there's going to be a preliminary hearing date set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon his bonding out, and he'll get a new court date in the mail. Is there anything else, Mr. Cox?
No, thank you, Your Honor, and I respect your decision. I'd just like to add one more thing. There's also like 4 separate civil actions against against my client where the other parties are suing him, and I wanted to make you informed of that I'm not sure what all you're seeing, but I do know that basically a lot of this may be coming from people who are suing my client civilly. But what I understand is I respect your decision, Your Honor, and I thank the court for its.
No, and I do understand that, and
I'm just asking if you just reduce those, take the 3 criminal damage charges, just make it one amount of bond of 1.5, and that saves him $1,000 plus. Now he can pay his attorney to help him represent him, and it's fair. I mean, all the charges are coming together as one. I understand. Thank you, Your Honor. I apologize.
No. It's fine. And that was something that I actually, as I was going through the warrants, that was a concern of mine as to whether the charges were being stacked. but from reading the warrants, it appears that it alleges separate events.
And I'm not sure about the facts of this case as far as that goes, so I'm not making any omissions or dismissions. But
yes, sir.
All I'm trying to do is all the cases they all will be tried together. I would take it, even though they're separate. But still, as far as the bond goes, I was just trying to focus trying to get his bond down, Judge, so that money that doesn't go to so that it can help him pay his defense here. But I understand and thank you, Your Honor.
Okay. Thank you, Mr. Cox.
Yes, sir.
You are free to go. And you, Mr. Aho, you're free to go back.
Judge, will you just make it clear to my client that his bond is $21,000 and he'll be able, he needs to 10% his attorney, the bonding company about $2,100?
Yes, sir. That's, did you hear that, sir?
Yes, sir.
Okay. He heard you.
Thank you, Your Honor.
Okay. All right. You're free to go back, Mr. Cox. So there's a person, David Hanu?
Your Honor, I was just listening in. I'm not party to anything here.
Okay.
Yeah, thank you, sir.
Okay, no problem. All right. Let's switch over to the ladies' side. Let's see if we can get this thing moving.
Just come up here, tell me the last name. Hold down noise. Tell me the last name. Or step back a little bit.
She's Alvera Hernandez.
Yes.
Ma'am, you've been charged with one count of simple battery. Bond has been set at $4,000. Do you believe you can post that bond?
I'll try and see. Talk to my family members and see if they can help me out with that.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Are you currently working, ma'am?
Yes.
About how much do you make per hour?
About $16 an hour.
Okay. All right, ma'am. You qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay. You're free to go back, ma'am.
Thank you.
Just tell me the name.
Good morning.
Good morning. You Miss Brody?
No.
I'm sorry, ma'am.
No, sir. I'm Monique Cosen.
Oh, okay. Miss Brody, I think I sent back. Tell me your last name, ma'am.
Cosen, C-O.
Okay. Ma'am, you've been charged with one count of harassing phone calls. I set the bond at $2,000. Do you believe you can post that bond?
I can't hear you.
Could you post a bond?
Oh, yes.
I placed a stay away provision on the bond to stay away from Angelina Carrera. Do you understand that?
Yes, sir.
That means no contact. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, I actually have a paid attorney. I don't even know why he's not here, but his name is Jonathan Melnick.
Okay. So your attorney doesn't necessarily have to appear at the first appearance hearing. But some attorneys do, some don't. Okay, so I'm going to check the box that you're going to hire your own attorney. Do you have any questions of me?
I do actually. I wanted to see if I could get a restraining order against her.
Depending on the facts and circumstances, possibly yes. but that's not something that I can deal with today.
Okay.
Is there anything else, ma'am?
No, sir. Thank you.
Okay, you're free to go back. No, I just realized I only got the CAA forms for the males, not the females. But we can deal with it. What's your last name, ma'am?
Christy.
Okay, ma'am, you've been charged with 1 count of simple battery, family violence. I set the bond at $4,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from a Jimmy Walden. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
No.
Okay, ma'am, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back.
Your Honor, I'm checking on the female CAA forms as well, as this going on now.
Okay, thank you.
Hey.
Are you Miss Duggar?
Yes, sir.
Ma'am, you've been charged with 1 count of simple assault. I've set the bond at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from, it looks like, Akila Duggar?
Yeah.
Do you understand that?
Mm-hmm.
Your preliminary hearing date is...
I'm sorry. I stay with her. So how's that going to work? I mean,
Let me finish what I have to say, and then I'll answer those questions, okay? Your preliminary hearing date is going to be set for November 30th, 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, ma'am?
Mm-hmm.
About how much you make per hour?
15.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, your first question was how you live together. How do you deal with that? So currently, you are the offender and she's the victim. So you're going to have to make arrangements with the sheriff's department as you're bonding out, and they will come to your house so that you can get your stuff that you're going to need for daily living. If she's not afraid of you, then she can contact the solicitor's office and she can try to get this condition modified or removed. The reason we place these conditions on these cases is we don't want whatever led to you appearing before me today to reoccur this evening. Because I don't know you and you don't know me and I don't know her. And the facts and circumstances, all I know is based upon the judgment of the officer that was there, someone was going to jail. Okay? What's your next question?
That was it.
Okay. All right, ma'am. You are free to go back.
Good afternoon, Miranda Franklin.
Good afternoon, Ms. Franklin. You're charged with 1 count of driving under the influence of alcohol. The bond was preset at $2,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a preliminary hearing date set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
We can try. I don't think I will, but we can try.
Okay, so you're currently working, I presume.
Yes, sir. 2 jobs.
About how much do you make per hour or per month?
About $25.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
Ms. Hires?
Good afternoon, Your Honor.
Good afternoon, ma'am. You're charged with one count of simple battery family violence. Bond is going to be set at $4,000. One count of reckless conduct. Bond is going to be set at $2,000. One count, of possession of marijuana less than an ounce. Bond is going to be set at $1,500, and one count of possession or use of drug-related objects. Bond is going to be set at $1,500. So you're going to have a total bond of $9,000. Do you believe you can post that bond?
I can try, Your Honor.
Okay. There's going to be a stay away provision on the bond, stay away from a Christopher Hubie. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You currently working?
Yes, sir.
About how much do you make per hour?
13.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So the Christopher Cubey, who I have to stay away with it from, he also apparently has the same charge as me. How is that going to work in terms of us both need to get our items from the house? So we both have separate stay away orders from one another.
I lost you after the how is that going to work part.
I'm sorry. We both have separate stay away orders from one another because we both have the same charge against one another. So how is that going to work in terms of us getting our items from the house?
So I'll answer it in the easiest ways possible. The two of you are adults and you should not be before me. And the problems that the conduct led to, that's something that the two of you created. I'm there. I put a stay away provision on his bond, stay away from you. And I honestly, I don't know. I don't know. I mean, and the deputies have heard this a million times. My wife and I have been married 19 years. The police have never been to our house.
Well, the police have been there before because he already had a stay away order from me, but he wasn't following.
I'm sorry?
The police have actually been to our house before because he already had a stay away order from me, but he wasn't following it.
So how did you get arrested if there's a stay away provision on for him to stay away from you and he showed up to the house?
It was in a car accident. It was what that happened. We were in the car together and he crashed the car.
So you allowed him to be in your presence?
Yes, sir.
Did that work out well for you?
No, sir.
Have you learned something from that?
Yes, sir.
Okay. All I can say is a word to the wise should be sufficient. So I'll say this. I don't know the previous order that you are speaking of, and without seeing it, I can't speak on it with any kind of authority. But if you knew that he was supposed to stay away from you and you allowed him into your presence, that order is pretty much, in my opinion, null and void. Anything else, ma'am?
No.
Okay, and I'm sorry I couldn't answer the question.
It's okay.
Okay. All right, you're free to go back.
All right, thank you.
Next question.
Is this Miss Lewis?
Yes, Your Honor.
Okay, ma'am, you've been charged with aggravated assault with a deadly weapon. I set the bond at $25,000. Do you believe you can post that bond?
No, I don't.
Okay. So there's going to be a stay away provision on the bond to stay away from a Trenton Gray. Do you understand that?
Yes, but I do have questions about that.
And we'll get back to that in a second. Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, I do.
Okay, are you currently working, ma'am?
Well, I just started a new job today. I was arrested, so I don't know if I still have that job or not.
Okay, I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Now, what was your question?
Well, I have several questions. My first question is, we have 4 children. I just found out I'm pregnant with our 5th child. We're a 2-parent household, just me and him. He has several charges in other counties. Nonetheless, our children don't have anyone, so they're currently in the process of being in foster care. I just need to be able to at least have a lower bond so I can get to our children. Our oldest child is 4 years old. Then we have a 3-year-old, a 2-year-old, a 6-month-old, and like I said, I'm currently pregnant.
Okay, ma'am, I would normally not set a bond on this. I'm giving you a break by setting you a higher bond. But when you allegedly stab someone in the abdomen, in my opinion, I, again, have to be concerned about public safety. And if you got 4 children and you got a 5th one on the way, your children should not be in the middle of this.
Understandable. My criminal history it's been over 6 years. He has about 3 cases back to back of domestic violence. So I understand the concern, but the reason that he was allegedly stabbed was because I was being victimized.
So, ma'am, why are you with him? Why are you with him?
As I just said, we have a 2-parent household and we have 4 young children. So I mean,
and a 5th one on the way. And you're saying that he is abusive to you, but you're still having babies by him.
If the system is not set up to help single mothers with these small children, what am I supposed to do? I mean, I'm kind of...
Ma'am, birth control. Birth control. Why are you having a baby by an abuser? You're telling me that he's an abuser, but you're also telling me you're pregnant by him.
Correct.
So, ma'am, that's a you problem. That's not a me problem.
Okay, I was just simply asking if the bond could possibly be lowered.
No. And I'm telling you, and the deputies will tell you, situations like this, I know bond people all the time. So hey, ma'am, you made some poor decisions. And you got to live by those poor decisions. And you can't ask for people to help you out of the bad decisions that you've made. Okay. And I hate to say it that way. I truly hate to say it that way. But ma'am,
I just need to know the amount so I can try to felicitate something to get in that order because I have to get my kids.
Okay, well, hopefully he'll help you get out of jail.
He's currently incarcerated. I just need to know the amount so, we can keep it moving.
Ma'am, you may be looking at your kids being taken away by defects. And I just got to tell you that. Based upon what you just told me, there's a very real chance that your children are going to be taken away from you.
I understand that. I just need to know the bond amount so I can actively go work on trying to get it posted, so I can try to do what I can to save my children.
$25,000.
Thank you so much.
Okay. Miss Moss. Ma'am, you've been charged with 1 count of simple battery. Bond is going to be set at $4,000. Do you believe you can post that bond?
I do.
There's going to be a stay away provision on the bond to stay away from a Sanjay Wright. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You currently working, ma'am?
I am. Right now I'm on maternity leave, so I go back to work at the end of the month.
Okay. About how much do you make per hour?
12 to 13.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am. You're free to go back.
Thank you.
Miss Shelton. Ma'am, you've been charged with 1 count of criminal trespass and 1 count of simple assault. There's going to be a $3,000 bond set on a criminal trespass and a $3,000 bond set on a simple assault. So that's a total bond of $6,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from a La Montez deal. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You currently working, ma'am?
Yes.
About how much do you make per hour?
17.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, ma'am, you're free to go back. Miss Spencer.
Yes, sir.
Ma'am, you've been charged with 1 count of simple battery. The bond is going to be set at $4,000. Do you believe you can post that bond?
No, sir.
Okay. There's going to be a stay away provision on the bond to stay away from a Carrie Pierce. Do you understand that?
That's my husband. I've been married to him since 1984. He's dying right now. The reason we got into a
Don't discuss it.
okay.
Yeah, don't, please, don't discuss
I
the
can't
facts.
hear. I'm jabbing my left ear.
Well, you're talking right now.
And he recently busted my. I can't hear. Okay. I'm sorry.
Ma'am, take a breath, calm down, okay? So the reason that there's a stay away provision on the bond is because of the allegations. Did you hear that?
Yes, I can hear, but it has to. If it's real loud, it's distorted. I heard. Yeah.
Okay. So again, there's an allegation of an incident that occurred yesterday.
Yes,
and we place a stay away provision on the bond because we don't want whatever happened yesterday to reoccur tonight. Okay? So this can get changed. He can contact the solicitor's office and ask them to change these conditions. Okay? And they have their own investigators. They will look into the case and they'll make a determination. All right?
Yes, sir.
So would you like for me to see if you qualify for the appointment of a lawyer?
I want to plead guilty.
You can't do that now.
Oh, okay.
You want to see if you can get your lawyer?
Okay. Ma'am, your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. If you don't have any other questions for me, ma'am, you're free to go back.
Thank you.
Okay. Ms. Ward.
Yes, sir. Hi, Your Honor.
Hi, ma'am. You've been charged with one count of driving under the influence of alcohol. The bond was set by schedule, which means it was automatically set at $2,000. You have also been charged with an open container violation. Bond is going to be set at $500. You're charged with use or possession of drug-related objects. Bond is going to be set at $1,500. And the final charge is obstructing or hindering law enforcement. And bond is going to be set at $2,000. So that's a total bond of $6,000. Do you believe you can post that bond?
No, sir. No, sir.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir, I would.
Are you currently working?
No, sir.
You said no?
No, sir.
Okay. Do you qualify, ma'am? I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, sir. I would like to see if I could get the bond waived. And the reasoning behind that is I was not driving. Do you have the report of the incident in front of you?
I have the warrant.
Does it speak to the details of me not driving, that I was in a parking lot at a convenience store?
It says you're sitting in the driver's seat of the vehicle.
Yes, sir. And I had been there. I wasn't driving or intending to drive.
So that's a trial issue for a jury to determine. The police do not have to see you driving. If there are facts and circumstances where they can deduce that you were driving and they believe that you were under the influence, they can charge you with that. These are allegations. The state has to prove this beyond a reasonable doubt.
What was the other question? I'm also a 100% disabled veteran. And that was another reason that I would like to see if I could get the bail waived. I have degenerative osteoarthritis, as well as other physical conditions that I'm not comfortable.
No, you don't have to disclose your medical.
I was just trying to justify. I've had surgeries on my knees, and I should be quiet.
Well, I'll tell you this, Ms. Ward. So the current process of determining whether a person qualifies for, we now call them UJR, unsecured judicial release, is that I would have to carry your case over to tomorrow to give me an opportunity to discuss your case with my boss, who makes that determination as to whether a person gets a UJR bond.
I'm not sure what that means to me.
He's going to talk to his boss,
Okay.
because you asked him, could you get a lower bond?
Okay.
And you're gonna come back tomorrow.
Okay. So I can still attempt to call somebody for bail.
You don't have nothing to do with that.
Okay. I think all the other questions I have will be handled here with the personnel here.
Okay. So I'm not going to carry you over, ma'am. I'm looking at your criminal history, and I do see that this looks like it's your first arrest.
Yes, sir.
Uh,
And like I said, I was parked. I know I should shut up about that, but it was no safety issue to no one. I wasn't driving or planning on driving. I was at the convenience store.
yeah, I understand. I understand. So, ma'am, I would suggest that it's in your best interest to go ahead and to make bond
Okay.
rather than waiting.
Okay.
Do you have any other questions?
No, sir. Thank you so much, Your Honor.
Okay, ma'am, you're free to go back. Miss Smith.
Yes, Your Honor. Yes. Okay.
Oh, and deputies, did you get the her fugitive waiver forms?
I do have it, Your Honor.
Okay, ma'am, you are you have the same rights and privileges as I discussed earlier when I was reading the script, but you're in sort of a special category in that you're being designated as a fugitive from justice, and what that means is that we have to. Through an intergovernmental compact, the states work together so that they hold people who are accused of being out of another state. And it looks like you're being charged with having a probation violation warrant out of the state of Mississippi. And before I go through my spiel, have you had an opportunity to speak to anyone yet about this process?
No, sir.
Okay. So you have the right to demand a hearing, and it's basically called a writ of habeas corpus. And at that hearing, a judge in Clayton County will determine whether you are the person named, whether you are Alicia Smith, and whether there is a valid warrant. And that's pretty much what will be determined at that hearing. If the judge determines that those two conditions exist, the judge will sign off on the governor's writ and send the paperwork to Mississippi. So sometime between now and 90 days from now, there will be a hearing. If you demand that hearing, there will be a hearing. I can't tell you if it'll be tomorrow or if it'll be on day 89, because I don't know. But if the judge makes a determination that you are the person named in the warrant and that the warrant is valid and signs off on it, the state of Mississippi will have up to 60 days to come and get you. The initial statutory period is 30 days. And if they don't come and get you within the 30-day period, somebody from the sheriff's department will contact Mississippi to see if they still have the intention of coming to pick you up. And if they say no, you can be released out the front door. But the warrant doesn't go away. The warrant will still be valid. So you can be released out of the front door of the sheriff's department, and 5 minutes later, you encounter another police officer, and they run your information. They see that there is a warrant for your arrest, and they take you into custody, and this procedure starts all over again. So do you have any questions as of yet?
No, sir. I don't.
Okay. Am I making sense to you?
Yes, sir.
So the choice is yours as to what you want to do. I just need to know what it is that you want. There's something that you should also understand and consider is that a bond, you can get a bond from the state of Mississippi. But you would most likely need to hire a lawyer to represent you down there. And you may want to consider that in any event, because we've had individuals where they've had these fugitive from justice warrants and they've hired lawyers. So lawyers have gotten bonds. I think last week it was a person from California, and a month or so it was someone from Tampa, Florida. And the Clayton County Sheriff's Department doesn't care. We're holding you for Mississippi. And if Mississippi contacts the Clayton Sheriff's Department and say, let her go, they're going to let you go.
Yes, sir.
So do you have any idea of what you want to do?
I want to sign the waiver.
Okay. So you sign the waivers, the deputies will then send it over to me and I'll sign it, and that clock will begin to run today. But I would also encourage you to try to get a lawyer and see what you can do for yourself in Mississippi.
Yes, sir. That was my intent. I wasn't able to use the phone just yet, but they're going to let me use the phone.
Yes, they will. Okay. I'm going to let you sign off on the waivers, and then you can be free to go back.
Thank you, Your Honor.
You're welcome. Give me 2 minutes, and then I'm going to go over to the mail side. I see we have 2 cameras up. Is there?
It's actually one more mail, Your Honor.
Okay. Who is that person?
Your Honor, that's going to be Mr. QB.
You can sign it right there.
Christopher QB, he's here by himself. And then the other cameras for the mail side.
Okay. So I didn't get that name clearly.
Christopher QB is the one I emailed.
Oh, okay. Well, you want to deal with Mr. QB right now?
Yes, sir.
Okay.
You can come up.
Mr. QB, sir, you've been charged with 1 count of simple battery. I've set the bond at $4,000. 1 count of failure to make, and looks like it says accident report. Failure to report an accident. Bond has been set at $500, and possession of marijuana less than an ounce. The bond is going to be set at $1,500. So you're going to have a total bond of $6,000. Do you believe you can post that bond?
Yes, immediately.
Okay. There's going to be a stay away provision on the bond to stay away from Destiny hires. Do you understand that?
I'm clear.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a notice in the mail of the new court date. Would you like for me to see if you qualify for the appointment of a lawyer?
No, thank you, Your Honor. I have a family lawyer.
Okay. So, Mr. QB, Ms. Hires, I don't know if you had the benefit of hearing her first appearance. Did you have that?
Yes, I heard that.
Okay. So, I don't know what is going on. And it's not my prerogative to know. You should speak to your lawyer about everything that's taking place. But there's going to have to be a decision made between the two of you as it relates to the home and the children. Okay? So I'll just put that seed in your mind and let it grow. Do you have any questions for me, sir?
I'm pretty sure this is not the route that I'm going to take, but I was curious about one thing. With the keep away order, obviously I understand that that works both ways. And I'm not going to try to get it taken away on my end. But one thing that I am sure of is that not only would I be able to go ahead and take care of my bond, but I do have contact. Well, I would be able to have contact with her family in order to give it to them, for them to be able to pay her bond, because I don't plan on having any contact with her at all. But I don't feel like it would be the right thing for me to just let her sit in this situation and I'm going to be out of it. Would that be something that could happen, or would that violate the keep away?
It would not violate the keep away or the stay away. The stay away relates to her. Okay. And she indicated that you have children. And that's something that it's a tough thing. So I'm not trying to get into the middle of that to prohibit or prevent any kind of issues as it relates to mother child, father child. But like what I said to her, you guys are adults and nobody wants to be in the middle of your life. And so to the extent that we get drawn into it, we have to make decisions. So I hope things can work out and they can change, but it has to start with you and Ms. Hires.
Okay, Your Honor.
Okay. All right. You're free to go back, sir. Okay. Give me 1 or 2 minutes, probably 1.5, and I'll be back in a second. Okay, I'm ready to get back started. Had to get me some orange juice. Is anybody there?
Yes, Your Honor. I'm here with all the mails, Your Honor.
Okay. Let's see. Mr. Bennett,
Bennett.
Sir, you've been charged with one count of aggravated assault. I set the bond at $15,000. Do you believe you can post that bond?
I'm not sure.
Okay. There's going to be a stay away provision on the bond to stay away from a Shaquille Peterson. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. Oh. These are out of order. Can you give me an average of what you earn? You placed on here that it varies.
That's off the list, so it's not like set amount.
I'm sorry?
I dropped the list, so there's no set amount.
Okay. I'm going to find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, that's all. You said the bond is 15,000?
Yes, sir.
That's all.
Okay, sir. You're free to go back. Mr. Brown. Sir, you're charged with aggravated assault with a deadly weapon. I set the bond at $10,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Shanta Lancaster Kimbrough. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I got my own.
Okay. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Campbell. Sir, how do you pronounce your first name?
Yeah.
Keon. Okay. Sir, you've been charged with one count of obstructing or hindering emergency phone call. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
You're going to have a stay away provision on your bond to stay away from a Prudence Amelita Baptiste. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. We also live together.
Okay. Well, currently you're going to have to stay away from her. Okay?
Yes, sir.
And the thing is, this warrant was written October 8th of 2021. So I don't know what's going to happen, but we don't want these situations to occur. I don't enjoy seeing people before me. So sometimes the only way to prevent these situations is to set an order so that people stay away. Are you currently working, sir?
No, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay, you're free to go back.
No.
Mr. Cortez.
Your Honor, he is not here, sir.
He's not. Okay.
No, Mr. Deal.
Mr. Deal. Sir, you've been charged with one count of criminal trespass. Bond is going to be set at $3,000, and one count of battery. Bond is going to be set at $5,000 for a total bond of $8,000. Do you believe you can post that bond?
Could you be able to tell me what's the percentage of that?
I'm sorry, sir?
Would you be able to tell me what's the percentage of that, or you not able to?
Are you asking me to reduce your bond?
No, sir, I said, are you able to tell me the percentage on the 8,000?
Oh, it's roughly between 10 and 12%. So that'll be $800 to maybe $900. Okay. There's going to be a stay away provision on the bond to stay away from a Mariah Shelton. Do you understand that?
Yes, but we currently have a child together. I was trying to see how would that work?
Okay. So do you have any custody arrangements in place, like from the court?
No, this all just happened yesterday.
So I was asking if there were custody arrangements that were in place prior to what happened yesterday.
No, it was just all me and Miss Mariah Shelton. We have a place together, and our daughter stayed with us. But I know I can't be around her, so I'm just trying to figure out how do I go about trying to get her.
Are you and Miss Shelton married?
No.
Has the child ever been legitimized?
Yeah, she has my last name. I don't think so.
So has there been a legal acknowledgement that she is your child?
No, I guess I gotta go make one then. I thought her having my last name was that.
In a general sense, children born out of wedlock belong to the mother, not the father.
Mm.
And unless you take steps to legitimize that situation, you may not be able to see your child. So you're going to have a preliminary hearing date set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay.
Sure.
How much do you earn per hour?
19.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No.
Okay, sir, you're free to go back. Mr. Is it Exum?
Yeah. Sorry.
Sir, you're charged with terroristic threats or acts. This is a felony offense. Bond is going to be set at $5,000. Do you believe you can post that bond?
No, he said $5,000. What is it, the bond is?
$5,000.
Sir, 500. Yeah, you know what I'm saying? I ain't had no terrorist threat. I was at my house. Your officer, he put them charges on me, but I just go to trial with it. I wouldn't take the ball because I was at my house.
Okay. Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. Do you plan on hiring your own lawyer, or do you want me to see if you qualify for the appointment of a lawyer?
I think I'm trying to get a lawyer for this.
Okay. Do you have any questions for me, sir?
No.
Okay, you're free to go back.
Your Honor, we do have Cortez, Justin.
I'm sorry?
We do have Cortez, last name Cortez. You called him before?
Yes, I do.
I have it.
Huh.
Come back to him.
Okay, Cortez. I do have Cortez.
Hi, sir. How are you?
I'm doing well, sir. You're charged with 1 count of battery, family violence. Bond is going to be set at $5,000. 1 count of cruelty to children in 3rd degree. Bond is going to be set at $3,000. So that's a total bond of $8,000. Do you believe you can post that bond?
I don't know. I have my family working on it right now. I'm gonna be honest. I'm kind of like innocent in this situation. I never put my hands on the mother of my child or my child. My child just happened to be in the room, and I understand that's cruelty to children. But I just have to fight this because like I didn't do anything to her. I actually left the house, and I have proof of that.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and there'll be a new court date mailed to you. There's going to be a stay away provision on the bond, stay away from Shania McKinney?
Mackenzie, yes.
Mackenzie. Okay. Would you like me to see if you qualify for the appointment of a lawyer?
I actually have a lawyer in all this.
Okay. So you should speak to your lawyer about this, and I would just tell you this, sir. This warrant was sought by an officer to a judge.
Mm-hmm.
So if what you just told me is correct, you have to consider the fact that the mother of your child lied to the police to get you arrested.
Correct.
And you have to decide what you're going to do about that in the future.
Can I ask you something?
Yes, sir.
What can I do about that? Because I'm not one to actually involve the police into my situation. That's why I left the house. But I want to know what can I do? Because this also affects my 3-year-old child, and I love him to death. So I don't want to take the police route. And a lot of people might say that's ignorant, but I'm just not that type of man or young man.
Mr. Cortez, you have to protect yourself. Okay? So if somebody is lying on me, getting me arrested, I'm going to stay away from that person.
Yeah.
If you choose not to, then you may have plenty of instances where you're coming before a judge. Okay?
Yeah.
All right, sir, you're free to go back. Mr. Finley.
Finley. Just right here. No, that's Finley. Yes, sir.
Mr. Finley, you're charged with criminal damage to property in the 2nd degree. This is a felony offense. Bond is going to be set at $4,000. Do you believe you can post that bond? I'm sorry, I didn't catch that.
Yes, sir.
There's going to be a stay away provision to stay away from a Mr. Battle. Do you understand that?
Mrs. Battle. Yes, sir. I understand.
It's Mrs. Battle?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir. But I have to figure it out when I get out to be for sure.
Okay. All right. I'm going to go ahead and appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I have no questions for you.
Okay, you're free to go back, sir.
Thank you. Great.
Mr. Gray, sir, you're charged with one count of simple battery. Bond is going to be set at $4,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from Alicia Lewis. Do you understand that? Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir? I'm sorry.
No, sir.
Okay. You qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back. Mr. Xavier Gray.
How you doing there, y'all?
Sir, how are you doing? You've been charged with possession of a firearm during the commission of a crime. Bond is going to be set at $3,000 for that offense. Possession of marijuana less than an ounce. Bond is going to be set at $1,500. Violation of Georgia Controlled Substance Act, possession of cocaine. Bond is going to be set at $3,000. And theft by receiving stolen property. Bond is going to also be set at $3,000. I'm sorry, $5,000. So you're going to have a total bond of $12,500. Do you believe you can post that bond? Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning. Courtroom 201, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
It looks like you put on your sheet that you make 48, close to 5,000 a month.
Yes, sir.
Okay. That is going to be over the limit. So I'm not going to be able to appoint a lawyer for you.
Okay.
All right. Do you have any other questions for me, sir?
That'll be all, y'all.
Okay. You're free to go back. Mr. Grisby?
How you doing, y'all?
I'm doing well, sir. You've been charged with several driving related offenses. Looks like it says decal not displayed. Bond is going to be set at $500 for that. Knowingly driving a motor vehicle with a suspended or canceled registration. Bond is going to be set at $500 for that. Open container violation. Bond is going to be set at $500. Violation of Georgia Controlled Substance Act, possession of THC oil. Bond is going to be set at $3,000, and possession of a weapon during the commission of a crime. Bond is going to also be set at $3,000. So your total bond is going to be set at $7,500. Do you believe you can post that bond?
Yes, sir.
Okay. Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. I make on the paper I put it varies. I make $19 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay. You're free to go back, sir. Mr. Holmes.
How you doing, Your Honor?
I'm doing well, sir. You've been charged with criminal trespass, damage to property. This is a misdemeanor offense. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond, a stay away from Tatiana Sanders. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I have a lawyer. I thought he was going to be here today, but I guess not.
Okay. Do you have any questions of me?
No, sir.
All right. You're free to go back, sir.
Mr. Horn.
Mr. Horn?
How you say?
Good afternoon, sir. You've been charged with one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And one count of use or possession of drug-related objects. Bond is going to be set at $1,500. These are both misdemeanor offenses. The total bond is going to be $3,000. Do you believe you can post that bond?
Yes, sir.
I'm sorry, sir?
Yes, sir. I can, Your Honor.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Are you currently working?
I am.
Okay. Let's see. All right. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. That's all.
Okay. You're free to go back.
Martin.
Mr. Johnson.
One moment, Your Honor. Mr. Johnson.
Okay. No problem. Oh, Deputy.
Yes, Your Honor.
I do have some ladies' names. The forms that I got back are only 30, and I thought I had 44 people on the calendar. I do know that some of the ladies were not on the forms. I don't know what happened. But I do have some ladies.
Okay. I'm over on the male side. I can, if you have the names, I'll be more than happy to grab that for you.
Well, I'll send a call, I think, to Miss Adamson and see what may have happened.
Yes, sir.
Because it looks like it's just some kind of mix up, because I didn't get them until we had been 12 minutes into the hearing. So we'll see.
So Johnson and Barisi, we're working on those two right now. We do have Martin, McCoy, and Morgan. We do have those, the rest of the males here.
Okay. Okay, no problem.
Yes, sir. Did you want to go forward with Martin and just wait for Mr. Johnson?
I'll put Ms. Johnson to the side. And you said Lou Barisi is there?
Yes, sir. We're working on him right now as well. Just those two, but the rest we have Martin on down.
Okay, let's go with Mr. Martin.
Mr. Martin.
Mr. Martin, sir, you've been charged with theft by shoplifting. Theft by taking as a misdemeanor offense.
Okay.
Bond is going to be set at $2,000. Do you believe you can post that bond?
Yes, but I suffer from a condition. But I realize I want to withhold the condition because I don't want you to know what the condition is, so you won't think poorly of it. But I suffer from a condition, and I have my own team that helps me pay stuff. Can I call them or get the number from them from like 411 or something?
Yes, you can dial 411 to get their information. They don't know that you're in custody?
No, I don't believe they do.
Okay.
If they went down here, that team went down here or something. I wasn't working with nobody.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer, Mr. Martin?
I would. The preliminary hearing, always a preliminary hearing. I probably have something. They probably time served. This is ridiculous. I was returning stuff, but it's all good. I ain't sure about it. Yeah. All that good stuff. What do you say?
Are you currently working, Mr. Martin?
I was trying to get a job.
So you're not currently working?
I am currently working, but I was trying to talk to somebody.
Okay, I'm going to appoint a lawyer. I'm going to appoint a lawyer to represent you, Mr. Martin. If you don't have any other questions, you're free to go back.
All right, thank you.
Okay, Mr. McCoy. Sir, you're charged with one count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. One count of driving under the influence of alcohol. Bond is going to be set at $2,000. One count of driving a vehicle with no insurance. Bond is going to be set at $1,000. And one count of driving a vehicle with an expired or invalid tag. Your total bond is going to be set at, $5,000. Do you believe you can post that bond?
I'm sorry, you said it's a DUI with alcohol?
Yes, sir. Well, it says driving under the influence to the extent that you were a less safe driver.
I don't know about that. All right. Yeah, I don't know about that, but all right. I can make bond.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
No, I'm good. I got one.
Okay. Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail.
All right.
You are free to go back, Mr. McCoy.
Your Honor, we got Mr. Johnson here. He's
Okay.
present right here. Mr. Johnson.
Mr. Johnson, sir, you're charged with one count of failing to register. The bond is going to be set at $10,000. Do you believe you can post that bond?
I might be able to.
I'm sorry, sir?
I might be able to.
Okay. Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
I just got a job.
Okay. What do you make per hour?
I'll make $11 an hour. I'm not doing this.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you.
Hey, ma'am, also offer something as well. I just also left the Peachtree Psych Board as well. We part of this.
I'm sorry, sir?
I just left Peachtree Psych Board 1 week prior to this as well.
You just left Peachtree Psych Ward and I didn't catch the rest of it.
I just left 1 week prior to this, prior to me getting locked up.
I'm sorry, I still didn't understand what you said.
I said, I just left Peachtree Psych Ward
1 week prior of getting the job.
Okay. Okay. Well, I've appointed a lawyer to represent you.
Okay.
All right, sir. You're free to go back.
LaBreeze. Mr. LaBreeze is coming up to Your Honor.
Okay.
Present now.
Mr. LaBreeze, you've been charged with 3 counts of entering an automobile. Bond is going to be set at $10,000 on each count. And 1 count of criminal attempt. Bond is going to be set at $5,000. So that's going to be a total bond of $35,000. Do you believe you can post that bond?
35,000?
Yes, sir.
Yes.
Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working?
Yes, sir. Yes, sir.
About how much do you make per hour?
18,000.
Okay, I'm going to find you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Go back to
Ms. Morgan.
Mr. Morgan, you've been charged with 1 count of unlawful conduct during a 911 call. I'm setting the bond at $1,500. Do you believe you can post that bond? Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Stay in the group home.
I'm sorry, sir?
Stay in the group home. I stay in the group home with my caregiver.
So is that a yes or a no to the lawyer?
Yes, sir. I do want a lawyer.
Okay. I'm going to find you qualified, sir. I'm going to appoint a lawyer to represent you. Do you have any other questions for me?
No, sir.
Okay, you're free to go back.
Parker.
Mr. Parker.
Yeah. Good afternoon, Judge.
Good afternoon, sir. You've been charged with 1 count of possession of marijuana less than an ounce. Bond has been set by schedule, which means it's been automatically set at $1,500. Do you believe you can post that bond?
Yes, Judge.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir?
No, sir.
You qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, sir, you're free to go back.
Mr. Payton.
Mr. Payton, sir, you've been charged with 1 count of violation of Georgia Controlled Substance Act. Possession of dangerous drug is what they have listed. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
No.
Okay, sir, you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, sir, you're free to go back. Is it Mr. Permeal?
Yes, sir.
Sir, you've been charged with 1 count of criminal trespass and 1 count of simple battery. Bond is going to be set at $4,000 on a simple battery charge and $1,000 on a criminal trespass. Do you believe you can make this bond of $5,000?
Yes, sir.
You
Yes, sir.
said yes?
Yes.
Okay. There's going to be a stay away provision on the bond to stay away from a joyful permeal. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir?
No, not at the moment.
Okay. You qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
All right, thank you.
Okay.
Peterson.
Mr. Peterson, sir, you've been charged with one count of criminal trespass, damage to property. This is being written as a misdemeanor. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on the bond to stay away from a Rashad Bennett. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Sorry, I keep lifting my glasses. That's a artifact of getting old. Would you like for me to see if you qualify for the appointment of lawyer?
Yes.
Are you currently working, sir?
Yes, I'll make 15 an hour.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
The roadblock.
Good evening, Rod.
Good afternoon, sir. You've been charged with one count of battery family violence. Bond is going to be set at $5,000, and one count of aggravated assault by strangulation. Bond is going to be set at $10,000. That's going to be a total bond of $15,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on this bond to stay away from a Sherry Eason. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 29th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes, sir.
About how much do you make per hour?
15 an hour, sir.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right, you're free to go back.
The Rick.
How you doing, y'all?
I'm doing well, Mr. Ricks. Sir, you've been charged with one count of simple battery. Bond is going to be set at $4,000, and one count of criminal trespass. Bond is going to be set at $3,000. Do you believe you can post that bond?
Yes, sir.
Okay. There's going to be a stay away provision on the bond to stay away from a Parisha Ricks. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, sir?
I don't know after
this right here, Your Honor.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, sir, you're free to go back.
Delete.
Mr. Wheat, sir, you're charged with 1 count of possession of marijuana less than an ounce. Bond is going to be set at $1,500. And 1 count of use or possession of drug-related objects. Bond is going to be set at also at $1,500. So that's a total bond of $3,000. Do you believe you can post that bond, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 30th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working?
Yes.
About how much you make per hour?
20. I'm sorry, $20 an hour.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Not at this time, no.
Okay. You're free to go back.
Thank you, Your Honor.
You're welcome. Mr. O'Keefe.
You coming up, Your Honor?
Okay.
Good afternoon, Your Honor.
Good afternoon, sir. Did you hear what I said to the other person, the female that was charged with fugitive from justice?
Yes, I did.
Okay. So you're in the same boat as her, except for in your situation, it looks like it's hard to read this writing. But from sheriff's office in Maine, and it looks like the allegation is there is a violation of condition of release. They've indicated that they will extradite. So Clayton County has no interest in your case up in Maine. We're only holding you because Maine requested us to hold you. So you have the same option. You can choose to waive extradition, or you can choose to have a hearing. And at that hearing, the basic determination will be, are you the person named in the warrant, and is the warrant valid? And the time period for the hearing will be sometime between now and 90 days. And I can't tell you when the hearing will happen. It could happen tomorrow. It can happen on the 89th day. If you were to waive that hearing, Maine would have 30 days to come and get you. And the statutory period is up to 60 days. So first period is 30 days. If they request an extension, that could be granted. And then if they don't come and get you, you will be released out the front door. Doesn't waive your warrant. Warrant is still valid. I will give you the same admonition that I gave her. It's probably in your best interest to hire a lawyer to deal with this up in Maine, because possibly, depending on what's going on, you may be able to get a bond up in Maine in a court date. And if Maine contacts Clayton County Sheriff's Department and say, release Mr. O'Keefe, that's what they'll do. So I'm giving you sort of a shortened version. But if you have any questions, please ask me.
No, I've already spoken to my lawyer and he's already dealing with Maine, so I'm going to waive extradition.
Okay. So the deputies are going to give you the waiver forms and you sign those and they will send them to me and I'll sign it and the clock will begin to run today.
Thank you.
You're welcome.
You have a good day.
You too. So, deputy.
Yes, Your Honor.
Oh, you didn't switch places on me. So I don't know what happened with the CIA forms, but I have 30. And I think I'm probably missing 14. And I do have some ladies. So it's not just ladies or men. And the forms were in kind of a crazy order.
We have a few down here. The ones that we have down here are for the ones who showed up late and NJ. So we have, they didn't fill out those forms, but everybody else who was in attendance, they filled it out, except minus the ones who came from intake that came that night. And like I said, with Mr. Johnson and LaBreeze, they didn't fill theirs out. I wasn't aware.
Okay, so when you send the waiver forms up, would you send those up also?
Yes, Your Honor.
Okay, all right.